This program is brought to you by Emory University.
Good afternoon. Before we get started, I'm going to give a couple of details about logistics and then introduce our speakers, and we will go right in. Most of you all know me from earlier trainings. I'm Karen Worthington, Director of the Barton Child Law and Policy Clinic here at the Law School, and I'm very happy to welcome new faces as well as those who have been at some of our earlier trainings back here. Today's program will go from now until 3:15. Sometime between 2 and 2:15 there will be a 10-minute break, and then our speakers will stop around 3 o'clock to take questions. All of these presentations are recorded and are posted online for folks who cannot get to Atlanta to see them. So it's very important that all questions are spoken into a microphone. Otherwise, we have gaps of silence and a little bit of oddness on the recording. So when you have a question, please wait for a mic to come to you, and then you'll ask the question. And that's also why we reserve the questions till the end, so we can actually get the microphones around to you. Very quickly, out this door, excuse me, in this hallway and in the far hallway are restrooms if you need those. Folks at the registration desk right outside can answer any questions. Please make sure you have registered and signed in at the registration table so we know who's here. If you need CLE credits, that's also where to get that covered, and so that you will have copies of the PowerPoints and any other materials that came out for today. If you parked in a place where you got a ticket, not the law school parking deck where you were waved in, but if you're actually holding a physical ticket, make sure you stop by the registration desk to get a parking token so you can actually get on your way home this evening without having to pay for that parking. So thank you very much, and now I would like to introduce our visiting scholars in practice for the month of March. We are very happy to have Judge Spivey and Judge Sumner here. First, we have Judge Spivey, who is with the juvenile courts in the Ocmulgee Juvenile Circuit. He is a native of Baldwin County and a product of our Georgia public school system. He went off to Washington and Lee for undergraduate and then came back to our own University of Georgia for law school. He had a varied career in private practice. He spent many years as a SAG, Special Assistant Attorney General, representing children. He worked in multiple counties in the Ocmulgee Judicial Circuit doing that. He also served as legal counsel for the Baldwin County Board of Education, so he's seen our court system and our policies from that side as well. And since 2000, he has served as juvenile court judge of the Ocmulgee Judicial Circuit. He also currently serves on the executive committee of the Council of Juvenile Court Judges. Also with us, we have Judge John Sumner, who is the presiding juvenile court judge in the Cherokee County Juvenile Court. He went to our own state schools of Georgia State for undergraduate and law school, and he also had a variety of experiences before becoming a juvenile court judge, serving in private practice representing parents, earlier work as a public defender, also as a guardian ad litem, and doing some criminal defense work. He also served time as a municipal court judge in the city of Woodstock. So bringing all of that experience forward to share with us about permanency planning. And finally, Judge Sumner serves on the Permanency Planning Committee of the Council of Juvenile Court Judges. So I ask you to please welcome our speakers here today.
Thank you, Karen. I think the challenge that the state of Georgia has at this time is to make sure that foster children receive permanency in the real sense of the word, and that this is done in an expeditious manner. We wanted today to explain the law involving the requirement for a permanency hearing and some of the practical tips that might be available to help us push the process, expedite the process so that children can reach permanency quicker. We're going to explain what a permanency hearing is. We're going to get into reasonable efforts in achieving permanency. We're going to talk about compelling reasons for the least acceptable permanency plan, which is what we call APLA. And we're going to provide you with some tools such as checklists that you have in your handout packet to help you do your jobs. Judge Sumner?
All right, thank you. I just want to tell you, we want to thank Emory for having us here. It is an honor. Is the sound working on the mic? Okay. All right. We just want to say thank you. It's an honor to be here. I think too oftentimes that the work of Barton Law Clinic and now they're outside. They need to come in. And Justice for Children, the Committee on Justice for Children, too often their work is overlooked. They are leaders in this area. They provide invaluable assistance, guidance. I think this training is just a wonderful idea, and we're so glad to be a part of it. And I'd like to just give them a round of applause, just say thank you for all their work. It's also an honor to be up here with my good friend, Judge Spivey. He's been around a little bit longer than I have on the bench. Extremely intelligent, very caring. As you'll see as we go through this, very detailed. We both have brought, I guess, our own experiences, and we hope as we go through this, it's going to help you as we're dealing with these cases when they come forward. I did want to share one thing with you, though, and I heard this at a conference many years ago, and the presenter said, you know, when you go to these conferences, you get all these materials, you get all these ideas, and it's kind of hard to remember all that, and you go back, you know, you try to put it into practice. And what he said was, try to remember one thing, just one thing that was the goal or what you were trying to learn from the speaker, and then everything else will flow from that. And what we've discussed here is that when you go back after today's seminar, or after this teaching, what we want you to remember, the key words are timely permanency. That is the point of everything that we're doing here today. So as we go through this, remember that what we're trying to seek and what we're trying to, and when we have some handouts for you, what we're trying to get across is that when we go back and we're handling these cases and we're dealing with the children who come before us, that our goal is to find a permanent and safe home and to do so in a timely manner. All right, with that, we'll go ahead and get started. And we'll go through some of these slides quickly so we've got more details. But why do you care about permanency? Of course, it's the outcomes for children and youth in foster care. Probably, I don't know if it's most important, but it is the bottom line. It's the federal requirement. If we fail to comply with the statutes in this state, Georgia is denied a lot of federal funding, which of course goes directly to assist the children. So, you know, we're doing this to comply with the federal statutes. As the dean mentioned, this is part of the federal review process, and what we're hoping to do is, as we go through this, that we have better permanency hearings in this state, and we're doing so more timely. The permanency, we want to shorten the time frames. We need to have these permanency hearings, have the goals.
Let me add to Judge Sumner that why do we care about it? The bottom line is that we want children to have stability and a sense of belonging, which may contribute to a sense of their well-being, and this certainly will play a role in the child's development. Kids in foster care, we believe, should have the same benefits and the same privileges from permanency as other kids, and that, I guess, is the philosophical bottom line.
Of course, my part on that as well, and agree with everything Judge Spivey has said. You know, when we discuss this with civic groups, you know, there's always, well, it sounds like it's just more tax dollars. It's just more money being thrown at another problem. The President came and spoke to us last night about trillions of dollars are being spent. Not saying right or wrong, just saying that's an issue. And when we discuss these, or when I talk to civic groups, you know, I always like to point out that we are dealing with children who are abused and neglected. They're going to have issues in their life. Now, this is not to say that every child who goes through these circumstances is going to be a failure. But what we're trying to do is to break this cycle. And if we find children safe and permanent home, and hopefully it's back with their parents, and we do so quickly that it minimizes the trauma, and what will happen is the children won't continue this cycle. And from a financial standpoint, You know, we would much rather have productive citizens, people who are happy, who are raising good families, than just continuing this and having it going on from there. The last line on this, though, is what I always like to conclude with when I'm discussing this. It's just the right thing to do. I think we have a moral obligation as a society. We have children who the adults in their lives, for whatever reason, are not providing for their care. And for those of us other adults, we need to step up to the plate, if you will. You know, we need to reach out to help the parents so they can take care of their children. But if they're not able to go forward and find places to live for these children. And it's just the right thing to do, to reach out to abused and needy children and provide care for them. All right. I want to talk briefly about case management. I'll let you know that I've actually had a whole seminar on case management before, so I'm just going to hit the highlights. If you'll notice on here, we have child-centered collaborative. The reason I like to use that is I like for everybody, and I know that we have a wide range of people here today, but whether you are a CASA or a guardian or a foster parent or a judge from the Department of Family and Children's Services, we all need to work together. We all need to operate as a collaborative. This shouldn't be the judge's solutions. It shouldn't be the department's solutions. It shouldn't be the faith-based community solution. We all need to come together. And, you know, that's not just from the front end of the case, but it's throughout the child's time in foster care. At every stage, and you'll see we're going to discuss a permanency hearing. Well, you know, you may not agree with the process, let's say. You know, you think that there should be shorter reviews or longer reviews or whatever it may be. But that is your system, and you are part of that. And you need to bring what talents you have and your views on it. We use stakeholder meetings quite a bit in our county. We have at least 4 per year. And quickly, I can just tell you, some of those meetings are very tense. We have people who have different views on different topics. But what I have found is if we all work together and there's a mutual respect there, that we can do what we're supposed to do, and that's put the child at the center of this. But as far as case management, there's different types, and I just want to hit them as an overview. And it really depends on the jurisdiction that you're in. It changes from jurisdiction to jurisdiction, from judge to judge. There are some systems that use what's referred to as a front-end loading, and that's where you try to have all the issues as quick as you can, relative placement, case plans, case plan modification. There are some counties which use citizen panel reviews, some do not. Different judges use different citizen panels in different ways. There are some that will wait till later in the life of the case to conduct judicial reviews. Whatever system that you're using, you know, we have found that the quicker you deal with the issues, the quicker that you move those to the forefront, you resolve those. When I first came on the bench, the hearings that we had our adjudication, and then we had citizen panel review, and then at the 11th month, you would have a permanency hearing. What would happen at that time is all the issues that you should have dealt with over the last 11 months, visitation, case plans, reunification, are the parents getting the services they need from the department, do the parents understand their case plan, all those issues were coming up at the 11th month. I was a defense attorney at that time. I can tell you routinely I would go in, I would argue all that, and we'd get a 6-month extension at that point. Did my client a lot of good because it gave them more time to work on their reunification, but didn't do the child any good. So what happened was we instituted a system, and just as an example of what we do in Cherokee County, is we have the panel reviews occur at 4 months after the child comes into custody. We have a judicial review at the 5th month. Generally, we have another one at the 8th month. By then, there's been 3 sets of eyes on that case, 3 reviews, and we know pretty much where the case is going at that point, and we'll discuss it in more detail later, but if we need to go to concurrent plans, whatever. But when we hit that 11th month, we have a good idea where the case is, so we can force this to come to a resolution for the benefit of the child. And so we're not dragging the case out 15 months, 16 months, 17 months. The reason we do this is 12 months to achieve permanency. I just want to go through this. Case management, as we say here on the slide, it's all about the path to permanency. And we wanted to highlight that, to say that every decision that's being made, no matter, and that's why I mentioned case management, just different examples, not saying one system's right over the other, but whatever system that you're in, every time you're at a review, it's not about how do I get through this review hearing, it's what's going on with that child. This is a child's life. We are making decisions that are permanently going to affect this child. We need to make the best decisions that we can. So, no matter what hearing you're at, the case management is all about finding your way to permanency. I like to tell case managers the life of the case is to be an engine for that child's permanency. If the case can't take that direction with a reasonable time, what are other viable options? That is, if we can't have reunification. And I just wanted to highlight, this just isn't a file. I know we all have time constraints. We all have 100 cases, and after we close those 100, we'll have 200 cases. It's just the way it goes. But this is not a file. It's a child's journey to find a safe and permanent home. And we'll go over those options more as we go through this. Just remember, once again, the goal on this is a timely permanency for that child. I describe often that, when a child is abused or neglected, they often turn to teachers or other adults in their lives or neighbors. And when they're placed in foster care, I think as adults we forget how traumatic that is for children. I've heard it from psychologists, but I've seen it in children. A child who has a rough time at home, when they go to school, there's normally a teacher or a worker there. They have that same set of playground that they're used to. They have familiar surroundings, and that's really how they're grounded. When they go into foster care, they're pulled from all that. They may go live with a relative that they don't really know. It may be in foster care. And I just think that's why, we need to shorten this time as much as we can. And as adults, to us, a year is not that long. 6 months is not that long. To a second grader, 6 months is a lifetime, where they're going to school, who their friends are. Just quickly on the statutory review, there's the first review within the 90 days. But what we're focusing on here today under the statute is as you approach that 12th month, what is going to be the permanency at that point. These are the required findings, contrary to remain in the home, reasonable efforts by the department, and whether the case plan is specific, correlated to the findings, and if it should be modified. Now on this next slide, I tell you, I guess I'm catching up with technology. Ever since I've been on the bench, we always tell parents, here's your case plan. I know Judge Spivey said this a million times. This is your roadmap to have the child return to your care. Well, I guess we had to update that and put GPS on it. So that's why we have a GPS on there. But with GPS, it's got to be correct. So your case plans, they need to be on point. And the reason I bring this up in a permanency discussion is that when you have that child first come into care and you develop that case plan for that parent to have that child return to them, you need to have that case plan on point. You need to say, what are the real issues of deprivation? Why can't that child live safely in that home? I don't know if any of you have ever had GPS and you're driving down and it says turn left, and if you turn left, you're going to run into a building or off the road or off a bridge. It's much the same with a case plan. Substance abuse evaluation. Well, there's no evidence of substance abuse, so that's just a waste of resources. That's not dealing with the issue that's going to have that child return to their parent in a safe way. Well, let me back up. Did we lose that one? No, you wanted to say something on that one, didn't you?
Well, what I wanted to point out is that when you're talking about reasonable efforts, the statute 151158 says that in making such reasonable efforts, the child's health and safety shall be the paramount concern. There's a tendency for defense lawyers to get caught up in the rights of the parents, and that's their job, and to hammer those on the record. But the law is clear that in finding reasonable efforts, and even in our all of our dispositions, the child's health and safety shall be the paramount concern. One thing I want to talk about in case management too, Judge Sumner, his talk about reviewing the case with the eye on permanency. The handout, one of the handouts in your packet, is a judicial review, which gives you an extensive checklist. And I was on the bench for years before it occurred to me that this was not defects driven. I guess it was because I was a SAG for 15 years, 17 years, and it had finally occurred to me that, you know what, I'm responsible, I'm the gatekeeper here, I'm responsible for the conduct of defects and making sure that they dot the I's and cross the T's. So this checklist focuses your attention on all of those issues. If you're like me and you tend to, your memory, I'll be 39 in September, your memory tends to fade after a while. You want to make sure you do not overlook any of these critical issues, because we're talking about the life of a child here. And it's, you know, when you get lawyers in the courtroom making motions and objections and so forth and so on, sometimes you get misdirected. But this little checklist and some of the others that we've put in here will help you do the best possible review that you can do. Now, not every line item is going to apply in every case, obviously. And you may want to lift this checklist out and put written findings, if you're the judge, in the order. But if you're defects, if you're a case manager, you'll want to be able to provide the judge with this information, whether it be from your testimony or the testimony of service providers and so forth. But these are all tools that you can use to get to that goal of achieving permanency in a timely manner and managing the case efficiently, as Judge Sumner is advocating.
And you raise a good point, that, and there's something that we had discussed. You know, I think we've got a lot of material to cover, so we're not trying, this is more of an overview at this point. You know, I think that too much what has happened is we've made the entire thrust, or the main thrust of what we do in juvenile court, as Judge Spivey just said, that the parents cross the finish line. That's how I say it. That it's all about that the parents complete their case plan. And there's almost a culture that, well, let's have a good adjudication hearing, find the real grounds of deprivation. Let's not say substance abuse when there's no substance abuse issues. Let's have that good GPS case plan. Let's have panel reviews. But it all seems to focus at that point on the parents. And did they meet their case plan or not? And then 11 months down the road, well, mom didn't make it. So now what are we going to do? And that's what we're here for today, to try to back up the process so that when that child is first adjudicated, when there's that first finding of deprivation, what we want you to do is to go back and start thinking what's going to be the permanent option for this child, because that's the right thing to do. So as you're going through this, and that's why we mentioned the reviews, and it's a child's life, and we're trying to get the focus away from, all right, parents, here's your case plan. It's like hand them off the football and say, let's see if you can make it to the end zone or not. And they fall a yard short or 10 yards short. If they don't show up for the game, whatever it might be, oh, now let's go to plan B. We don't want that. You want plan B from the first. I'm not talking about concurrent. And so when we were talking earlier about the collaborative, that child-centered collaborative, and I could borrow your order for just your judicial order. All right. And a lot of judges, we've developed orders like this, or we have particular findings. This is a great order, your judicial review order. All right, you're part of the collaborative. You're in Judge Spivey's circuit. Oh, I can't stand these review orders. Oh, he's going to ask 10,000 questions. Please don't make me go to court. Well, guess what? He's the judge. That's how he manages his cases. One of my SAGs are here. She practices all. Hey, how are you? We manage his cases differently. But you know what? How you manage cases, judge-driven. When you come in, be part of the collaborative. Say, okay, that's the review. That's what the judge is looking for. I think he's the greatest judge. I think he's not the greatest judge. That doesn't really matter. Sorry, Judge Spivey, but none of that really matters. What
Well, I hear
matters,
that a lot.
So do I. It's the child. So that's the parameters you're walking in. So you know, and we're going to go through these other checklists. When you go to Judge Spivey's court, you better be ready to answer all the education questions. That's part of being in the collaborative in this court. So we did want to emphasize, though, you know, of course it's correct and it's important for the parents' rights. We want the child to go back home if they can, but let's not fall into this trap of let's just see if the parents can make it across the finish line or not. So as you come in from whatever discipline you're from, CASA, guardian, DFACS, start thinking, well, what do we do on the relative search? And that statute's there for a reason. That's required. We want to start looking for relatives. Let's say there is a reunification. What's wrong with finding good relatives to help this mother if she's made those changes in her life? So, all right. Issues during the permanency journey. Of course, the reasonable efforts being made by the department, and we'll go through more of this in the details later, but basically it is a federal requirement, and we have, I don't know how this is available, making it permanent. Have y'all seen this? We received this from the Justice for Children.
Yeah, it was put out by the American Bar Association several years ago. I had found some information that I had and asked Michelle Barkley if she could get me a copy of the book from which I had found some of this information, and that she started digging and determined that it was out of print. So she made one of her contacts, I believe it was in Chicago, maybe at the ABA, I don't recall, and lo and behold, next thing I know, this comes in the mail. Michelle is a magician, and this is an excellent text. I recommend it to anyone who is interested in permanency for children in Georgia.
The name of it is Making It Permanent. It's through the ABA, and the first offer is Vermonte and then Rainey, but it's Making It Permanent. The reason I wanted to mention this book is if you will go to the foreword in it, and I think this helps you to understand, it certainly helped me, the historical context of where we are on this. The short of it is this: the federal government has decided, as Judge Spivey said, the judges are the gatekeeper. We are the ones to make these determinations. We are the engine. Doesn't mean there are cases alone, doesn't mean we don't all work together, DFACS doesn't have responsibilities, etc. But the judges are the gatekeeper. We are the ones who are responsible for making all these findings. So these are not just something that we made up at the judges' seminar. This is a federal requirement. When the case comes, the judge has to make a finding that the department's made the reasonable efforts, accomplished the goals of the case plan, visitation, finalized permanency plan, any placement issues. Judge is required throughout this permanency journey, that's the 12 months of case management. Relative search has been conducted, the parents' efforts towards meeting the case plan, and what the permanency plan is. Those are all federal requirements. If the state fails to meet those, we lose Title IV funding. Without funding, we cannot provide services for these children. That's why it is a federal requirement, and that's why we go through this. And what we hope is through these learning series that we're able to develop, as you said, the toolbox, the checklist, better ways to make sure that we comply with federal law. All right. Judge Spivey.
Okay. The definition of permanency was given to us by Judge Crawford last month at this very seminar, And I'm going to read it to you. It's lengthy, but I think it's necessary to encompass all the necessary elements of permanency. A safe, nurturing, and stable home environment and set of relationships, an opportunity to live in a permanent home, one which can be returned to for support even as an adult, a home intended to last indefinitely, a family which gives a commitment to continuity for the child and allows for lasting, supportive, lifetime family relationships to be established, and gives the child a sense of belonging and definitive legal and social status. Now that's a mouthful, but basically this addresses what I was talking about in the beginning: stability, a sense of belonging, a sense of well-being, and all of the benefits that are derived from being a part of a real family. So those elements are the essence of permanency. So when you're talking about achieving permanency, that's what we're talking about. And that's a tall order when you're dealing with foster children. You'll be lucky in some cases where you can achieve that more easily because of the availability of relatives. But in some cases you won't have that. There will also be other obstacles such as behavior problems, various disabilities that these children may have. That requires us to redouble our efforts. And it also requires us to be very suspicious of the last permanency option, which is an APLA, and we're going to talk about that very soon. We also, in addition to the children must be removed, when they have to be removed for their safety, permanency planning efforts have to focus on first returning them to home as soon as we can. Now Georgia is doing a very good job of this, or they're doing an adequate job of reaching reunification in a timely fashion. That's not why we're here today. We're here today because the other options, guardianship, adoption, another planned permanency arrangement, these other plans, we're dropping the ball. We're slowing down on permanency. We're not pushing across the goal with regard to permanency. And we're being docked by the Fed for that. So, what is our role in this process? Everyone has a role, and as Judge Sumner says, it is a collaborative effort. We need to identify our roles. The department has one of the most important roles because you're managing the case. But there are all of the service providers, the independent living coordinator, the educational advocate, all of these facets of the child's life, they all have to be there. I can tell you from personal experience that when I started on the bench, I didn't even have as much in the way of resources as Judge Sumner. We did not even have citizen panel reviews. And we had 8 counties, and all of our plans were just signed off on by Superior Court judges. So there was no actual review hearing, period. We've come a long way since then. And but it seems like the faster we run, the faster we're required to run. So this is a work in progress. I know it is in the rural circuits, and I'm not so sure it's not in the metro counties. But whatever your role is, whether it be the case manager, the educational advocate, the independent living coordinator, the judge, the guardian ad litem, the CASA, it's important that you identify that and fulfill that role. Now let's get to the permanency hearings. What is a permanency hearing? Well, this is a representation of the deadline for the court to determine the final plan. As Judge Sumner has pointed out, we're required at 12 months to have that hearing. Now, The Georgia statute 151158 has talked about a permanency hearing for a long time. I don't know about all of you, but when that statute was passed, it doesn't define permanency hearing. It doesn't tell you what you're supposed to do at that hearing. And so a lot of us out in the boonies have had to just kind of figure out what it is we're supposed to do. Fortunately, with this book and with some of the information that we have been given by the Committee on Justice for Children, a lot of us are now structuring these hearings and coming up with these checklists. I devised my permanency checklist, which is also in your packet, permanency hearing checklist, from a number of different sources. I went through a number of sources and just said, what are the key elements that we need to have here? This is not the end-all in way of checklist. I'm sure you can improve on it. But for me, in my circuit, it's a beginning. Do I get a lot of hollering and carrying on because these hearings last 2 hours? I certainly do. I get a lot of eye rolling and a lot of sighing. But, you know, I really don't care.
He doesn't. I can tell you that. He doesn't.
But what we're doing is having a hearing to determine what is the best option, what is in the best interest of the child as far as permanency is concerned. This is a review hearing on steroids. That's what it is. And if you look at this permanency checklist, you'll see that most of the issues that you're going to be required are there. There's some of them that can be expanded on, and I have expanded on it when you get to the educational part with this education checklist, which comes from the National Council of Family and Juvenile Court Judges. This is an excellent checklist, in my opinion, because it's exhaustive. It covers most of the areas that are tangential to the child's education. And
why do you have the education checklist?
Well, the reason you have that is because you want to make sure that wherever the child is placed, that the child is receiving all of the benefits, including education, that the child is entitled to, and that these benefits, that these services are meeting that individual child's needs. Ideally, you would like to have a educational advocate from the school, but that doesn't have to be a school teacher. It can be, it can even be the defects case manager. If they keep themselves up to date on this information in the checklist, a lot of times the case manager is one of the child's best friends. So certainly that a good case manager can be an excellent educational advocate. But if you've got a case manager with 100 cases, you know, it might be better to have someone at the school who is taking on that role. So the fact is that you want to have a hearing where everybody is brought to the table, brought to the courtroom, and is allowed to be questioned by the court.
Let me interject just for a minute. In line with that, back when I was talking about case management, now, Judge Spivey, you don't have citizen panels in all your counties, correct?
I have them in 4 of the 8.
4, okay. He has 8 counties, you heard correctly. 4 of the 8. And as I said earlier, citizen panels are used in different ways. In our county, and this is through the State Council, and we developed this through the Permanency Council, State Council of Juvenile Court Judges, there's a very detailed, and this covers your education list, it's a very detailed checklist that our panel reviews will go through for the child. We were going through that, and what we tried to do is track it. Are they getting visitation with the parent? And these are all issues that you'll address in court or that can be addressed in a review hearing. Are they getting the visitations? Are all their educational needs being met? Are their medical needs being met? Are their mental health needs being met? In our citizen panels on the educational part, we have them ask, is the child in extracurricular activities? How is that going? A lot of times, think about it. You're sitting there, oh, extracurricular activity, Maybe there's a coach or a parent there that has a connection with this child, someone who might be a fictive kin at that point. Medicines, I've got an example of a case I'll use later. We really try to monitor. We're not doctors, but when I see a child going from 2 medications to 10 medications, now I don't know what those medications do, but it's a little red flag goes off at that point. We've gone from 2 medications to 10. Now, the point of that is under the case management and with our checklist here, that's how we're looking out for the best interest of this child and helping that child to achieve permanency, because we're looking for any problems that that child might have or any strengths that that child might have. So whether you're using panel reviews or through the court hearings, whatever review hearing you're using, you know, it's not just how's parent doing, how's child doing, child's doing fine, grandma reports no problems, thank you very much, next case. Oh, thank goodness, well, I'll make it to lunch now. It's not that. What's going on with that child? Think if it was your child living away from your home, what questions would you ask about that child? Is he still on the ball team? Is she still going to the gym? What medicines? Why is she on those medicines? Why am I visiting my child more? So that's what you're doing in a review hearing. And at the permanency hearing, it's all of that plus, and we have that on the screen. So I just wanted to interject with that.
That's right. You want to cover all of these subjects with regard to the review, but you also want to go to the question of whether this is the best plan for permanency for this child. And you do that by systematically ruling out the plans that aren't the best. You have to consider the health and the well-being of the child. You have to go ahead and order the next steps to achieve the permanency plan. You have to rule on whether the agency has made reasonable efforts to finalize the permanency plan. And the question of reasonable efforts, that is going to be, you'll see that your checklist is going to help you there. The question is, what services has the department provided for that? And as well, if you have a concurrent plan, for instance, and we may talk about that later, but I want to use it in this context. It's important for the agency to front load that concurrent plan too in the front. For instance, let's say you have a mom who's going to be working a reunification plan and the concurrent plan is adoption. Should the department wait until the permanency hearing to start recruiting adoptive parents? No. But this is what I find when I have the permanency hearing. Now, I hope that within a year in my circuit, not one of my counties will be doing that. But you have to work both plans concurrently. That's what it means. And if the court approves that concurrent plan in the dispositional order, then that is a plan just like reunification is.
Skip ahead then. Well, what triggers a permanency hearing? We've discussed that. Just refer you to the statute, because I want to make sure we get to that other part.
Okay.
Say permanency hearings in Georgia, just look at the statute on this. There's certain types of cases, the more serious cases, where you'll go directly into a non-reunification, and that's under the statute. Let's see.
And while he's looking that up, let me just say non-reunification is not a permanency plan. I hope nobody in here thinks that is the case. In the old days, that was what you heard. What's the permanency plan? Non-reunification. Well, that's not a permanency plan.
Okay, we'll jump. Yep, there we go. We'll come back. I call it the non-reunification trap. Years ago, we had a problem when the department would stand up and say, well, at this time, the plan is non-reunification. That's not a permanency plan. That's where we go to Plan B, and that's when we start asking these questions. But we should have all moved in this state beyond accepting that as a permanency plan, but it's still the culture. It's still this goal line. It's still this culture of, well, we waited till the 9th, 10th month. Oh, mom made it to the 1 yard line. Now what are we going to do? And that's what we're really trying to push to practice in our state, is to start thinking about what if we have a non-reunification? What are other possibilities? So let's not just stay on the parents' issues, but let's start looking at potential other avenues. So I don't think we have as much problem legally with that being accepted as a plan in most jurisdictions, but don't get wrapped up in the culture. And when you go back, you'll probably see people who think that, whether it's department or staff or whatever it may be. Start working on them. Let's move our system forward and start saying, well, it's the 5th or 6th month. Let's move beyond the parents. What's plan B in case we end up in plan B? So let me go back.
An example here is a parent who has a drug or alcohol addiction. We all know that takes a long time to control in some cases. If you, by the 6-month review, that parent has not made any progress, has not gone to treatment, has not submitted to drug screens, then my conclusion is we look at Plan B at that point. I get a lot of resistance from DFACs on that, but let me tell you, I have a drug court, and I also assist our Superior Court judge in her drug court, adult drug court, and I can tell you, I'm not going to stand there and let this child's life just tick away while this parent cannot decide whether to go to treatment or is resisting it. So I'm sorry, but that's an example of let's go ahead and do Plan B.
Let's see, we got ahead of ourselves. Let's see, what slide?
Let's see.
Permanency hearings. What triggers a permanency hearing?
Yeah, I think we got ahead there.
There we go. It's on page 6.
Okay. I want to say on the previous slide too,
Yeah,
the
let me
12
back up
month.
one, yeah.
You notice that there's a 12-month requirement. You have an extension hearing and you have a permanency hearing. May they be held simultaneously? Yes. Are they the same thing? Absolutely not. You determine whether there should be an extension, and usually that's going to be stipulated, because by that time, if the parent has not made reasonable efforts on the diligent progress rather on the plan, that's not going to require a full hearing. Sometimes it will. But the permanency hearing is separate from that. You can hold it at the same time. The orders ideally should be separate. And we're going to talk about orders later, but if I don't remember to say that, you should try to have a separate order. If not, if you have it in the same order, the extension and the permanency hearing order, you can do it under a separate heading. You can do the order of extension and then make your findings there, and then at the end do a permanency order heading and say this is what we found, reasonable efforts to finalize the plan, and so forth.
Let me direct your attention. It's 1511-58, subsection O, subsection 2, and we'll cover this in another slide coming up, but it's 5802. And if you look at that, it describes exactly what a permanency, well, it states what you must comply with, and it's very specific findings. If you go back to 58N, it discusses custody extensions. So by statute there are 2 different findings. So when you come in for those hearings, it's, like you said, it's fine to have them at the same time, but the issues are not the same. As I said earlier, there's a non-reunification trap. There's also a custody extension trap. Well, we've extended custody, Judge. We'll set up for a review in 3 months. No. We're going to have a permanency hearing now. And that's what as we were going through, and if you look at the statute, it'll show you everything that you need to go through for that permanency hearing. Reasonable efforts, what are other plans, are the child's needs being met? All right, and there it is, 02. Do you want to discuss the teams on that?
Yeah. This brings up, is this 16?
Yes.
Okay. I would point out that, and I think we've touched on this, is the court should build in lag time if there's going to be a TPR filed. At 12 months, the department has to report under this section to the court whether or not it intends to file for termination of parental rights. And if it does not at that time, there has to be a compelling reason why it has not filed that. But I want to be sure that you understand that there's an inertia with this process, because all of us have other cases to deal with. And so it's important that you anticipate lag time in obtaining a TPR order if adoption is the permanency plan. The personal service for the TPR petition requires 30 days, and often, many times, as you know, the parent cannot be found within the state, so that there must be publication of notice, and that's going to take up to 60 days. So I have a local rule in our courts in the Okmulgee Circuit that requires the department to file for an extension of custody no later than 60 days before the expiration of the order. Now,
Question. Have you ever had have you ever had it set for a hearing and there's been no petition for extension?
yes.
Hey, what do you do, Judge Spivey, at that point?
Well, that's when steam comes out of my ears.
Yes.
But no, this is routinely violated, by the way.
and it shouldn't be.
And I don't know why it is, but I will say this, since I have had the steam come out of my ears, and since I've had this rule, at least most 99.9% of the time, we're getting those hearings by the time of the expiration. We're at least getting that done. But we could have already approved permanency at least 60 days earlier than that, maybe 30 days earlier than that. It's a work in progress, what can I say?
But it happens.
Now, here's a question that we wanted to ask with regard to this slide, and this is really important because I want to emphasize that you cannot use a checklist or a template to decide permanency for these children. We had a teenager who has a child. Both of them are in foster care, the teenage mother and the infant. The question is, should this teenage mother get any slack on completing her reunification plan in 12 months, or should the TPR be filed at 12 months in every case? Well, the answer, of course, is you look at it on a case-by-case basis. If this teenage mother, like the one I have in Greene County, is complying with her independent living plan, is now enrolled at the University of Georgia, one of the greater institutions of learning in our state, then yes, absolutely you give her more time. You give her more time and you try to help her in every way you can. But you've got another mother who has not only not followed the case plan, does not attend independent living meetings, shows no interest in it whatsoever, but has in fact gone out and got pregnant again and is about to have another child. I think we need to hold her to the same standard we would an adult parent when it comes to reunification. So, no, the answer is no. You cannot have a hard and fast rule for permanency for every case. You have to look at the facts and circumstances of each case at the 12 months.
Now, the way we've handled the teen cases in our jurisdiction, and it's exactly as Judge Spivey's saying. I mean, it really is case by case. You know, there's some teen mothers who turn out to be wonderful mothers, provide for their child. It just takes time. They need extra services. You can't have a hard and fast rule. You can't really on any case. But the way we handle it is that when a teen mother's in care, of course, she has her child, the court has no authority to place. We can't force a placement anywhere. That's up to the Department of Family and Children's Services. But I'm always left in the quandary of this, and I've asked them this on the record. I've got a teenage mama. We've got to figure out in 12 months, can she provide care or not? If she's getting her 2-hour visits a month, it's real easy to be a mother like that, isn't it? I've asked the department, how are you really going to know whether she can take care of this child or not? Let her have to get up at 2 in the morning and then get up and get ready and go to school. Then you'll know. And it's not so much whether the mom has the skills, it's whether she's got the desire. And I don't want to say heart, but if she has the desire or the abilities. I just had a case earlier this week. Teenage mother surrendered rights. And she said she did it because she knew it was the right thing for her child, that she just couldn't provide the care, and she had a wonderful adoptive family. So what I've told the department is I can't order placement. You place as you can, but I can guarantee you when we come back and I have to make reasonable efforts finding, and this teen mama is seeing this child 2 hours a month, that's not reasonable efforts in my courtroom. I've never had a case where they could not at some point find a placement for that mother and that child, or a foster parent who is willing, and it takes a special foster parent to take these children in, but that was willing to allow a lot of ongoing, every day after school, on the weekends. In every one of those cases, we've had great success. It's not whether the mom has the skills or not, it's whether she has the heart. But we use reasonable efforts. That's how we got around to it. So when you have those cases come up, look at your local jurisdiction and then see how we can find out, rather than just having that magic number of 12 months later, did she make it or not? So, all right. Did you want to take our break before we get into the various plans?
I think that's a good stopping place. If you want to take a 10-minute break.
Let's take a quick 10-minute break, and then we're going to get into the different selections for permanency.
The preceding program is copyrighted by Emory University. Please visit us at emory.edu.